Well, hello, we are on air, and this is me, Lior Samfiru, the employment lawyer, welcoming you to your employment law live stream session. That was a mouthful. Welcome to this live stream. This is where you get to find out questions and answers about employment law and workplace rights and get those issues resolved. Again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. And I was here Wednesday, and I'm here back today on Friday to talk to you about employment law and workplace rights, and to make sure that you know what your rights are, that you know what the law can do for you. This is a live session, which means I want your questions. I'm here for the sole purpose of answering questions, helping you with those issues, and making sure that you have the information that you need to preserve and fight for your legal rights. If you're having a bad day at work, your boss did something or said something, and you're not sure if it's legal and should they do that? Should I do something about it? How do I respond? Don't wonder anymore. Ask the question right here, right now. If you're dealing with a situation where your job is being changed, maybe there's cutbacks, you're losing your job, you're being laid off, you name it, whatever that issue is, you can call or you can email or post the question right now, and I'll see it. There's a box on the screen. You type in your question. You hit the enter button, done. It's right there. I'll see it. I'll read it. And of course, I will give you that answer. I was very busy last Wednesday. You guys kept me busy, which is amazing. I want to be even busier today. All right. It's Friday. Let's have some fun. Let's get tons and tons of questions answered. Keep them coming, and I'll keep answering them. Now, before I start answering questions, I want to give you some other contact information. This is only a 30-minute session. Beyond these 30 minutes, so very easy to get a hold of me and my team. You just have to go to employmentlawyer.ca. See that address right here. Employmentlawyer.ca, the place to go to. Phone number, of course, right there. Email address is right there. All of the contact information you can use is right there. You can read about employment law there. You can find out more about your rights. What a great resource for you. Again, employmentlawyer.ca. But right now, I'm live. I see some questions have come in. Guys, ask your questions. I know you're watching because we got tons of people watching this. Don't be afraid. Ask your question. If you're in Ontario, BC, Alberta, if you're in Canada, you want to get some answers to your questions, ask them. Let me help you. Let me make sure that you know what your rights are. All right. I'm going to start answering questions right now. And as you listen to me, I want you to ask your questions. Again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, getting ready to get to work. All right. First question today, and thank you for that, comes to us from Facebook, and this is Andrew. My employer changed my holiday pay. If I work 12 hours on holidays, I only get paid holiday pay for 8 hours and straight pay for the other 4. Many more changes like that have happened. Is this allowed? No, that's certainly a breach of employment standards legislation in terms of how holiday pay is calculated. This could potentially also be a constructive dismissal, not the type of change your employer is allowed to do. Best thing for that, file a claim with the Ministry of Labor. You can't go there if you lose your job. You can't go there if there's a layoff, a temporary layoff. You can go there if they're messing with your hours and your holiday pay. So do that, Andrew. Again, go to the Ministry of Labor, and thank you for that. All right. Let's see here. Want to make sure that I'm not missing anything. Let me just see here. Fantastic. Okay. Next question today. By the way, guys, me, Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. Let's get to answering questions. I've been working for 15 years in a leadership role. And this is Jessica, by the way. Next question, Jessica, YouTube. I've been working for 15 years in a leadership role with no employment contract. I was recently placed on a temporary layoff, which then became permanent. They offered me 28 weeks. Do you think that is sufficient? Does the layoff period change my entitlement at all? That's not even close to being sufficient. Now, what you didn't tell me, Jessica, is how old you are and the type of job that you were doing. But just based on the 15 years, you'd easily be owed 12 months of severance. Okay, they offered you 28 weeks, which is 6.5 months. You're easily owed 12 months. And depending on your age and your position, it could even be much more than that. It could easily be as much as 18 to 20 months. So that's a wrongful dismissal. You've been wrongfully dismissed, Jessica. You've been wrongfully dismissed because you're owed a heck of a lot more severance than 28 weeks pay. So what do you do next? Easy. You reach out to me. You connect with me through employmentlawyer.ca. Again, employmentlawyer.ca, and I will help you. I will make sure that you get the severance that you're owed. That's what I do. We have a whole team that does that. And this is, by the way, such an important question because it's very, very common. You're let go, whether it's through a temporary layoff or otherwise, doesn't matter. Company offers you something, and how do you know if it's appropriate? Well, it's likely not. 90% of the time, it's not appropriate. It's not even close. I'm going to give you a tool right now. You can find out also how much severance you're owed without even having to contact me. You can always contact me, and I'll tell you how much severance you're owed, just like I did with Jessica. But I'm going to give you another tool right now. It's called pocketemploymentlawyer.ca. Right here, pocketemploymentlawyer.ca. When you go there, just click on the severance calculator. Couldn't be simpler, right? Click on that severance calculator. You answer a few questions, and you can find out in seconds, literally, how much severance you're owed. So Jessica could have done that to find out if the 28 weeks is appropriate. She would have seen on the calculator that she's owed twice that. You could do the same thing, by the way. If you lost your job, you go to pocketemploymentlawyer.ca. But maybe you haven't lost your job. Maybe you're worried. Maybe there's going to be some cutbacks, AI, tariffs. You want to be ready. Again, you go to pocketemploymentlawyer.ca. Or maybe you're just curious. A lot of people are curious. They want to know, hey, what would severance be like for me? Is it a week per year? Is it 2 weeks per year? Of course not. It's a heck of a lot more than that. A heck of a lot more. So again, severance calculator, you'll find that at pocketemploymentlawyer.ca. Nearly 3 million Canadians have used it. Use it as well. All right, fantastic. Great start here today. If you're just joining us, I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin, LLP, here for you at your service, answering questions. I see some more have come in. I want your question too. Keep me busy. Keep me on my toes. Keep me sweating. By the time this is done, I want to be out of breath. And you can do that by answering or by giving me the opportunity to answer a question. Ask yours. Thank you for questions. Let's continue answering them. All right. Next question to us is from Reddit, and this is Lindsay. My workplace is toxic, but not necessarily illegal. At what point does a hostile work environment become a legal issue? So again, you're saying it's toxic, but not necessarily illegal. Well, how would you know, right, that it's not illegal? It may well be illegal because any toxic work environment is illegal. You have a right, we all do, have a right to work in a supportive work environment, in a healthy work environment. If our work environment becomes hostile, becomes poison, often we call it the poison work environment, that's not legal. It means our employer is not properly protecting us and not properly fostering a supportive and proper work environment. So if you're truly working in a toxic work environment, you're mistreated, you're bullied, you're harassed, not legal. So what do you do about that? You tell your employer in writing about that. You send whoever the right person is at your employer, whether it's HR or someone else, you tell the right person in writing, here's what's happening. Give as much information. Once you do that, they're under a legal obligation to investigate and take measures to fix it. They have to. It's not that they should be doing it. They must do that by law. If they refuse, if they don't do it, if they ignore it, if nothing happens, let me know. Connect with me as soon as possible, and I'll deal with it. Okay, you can reach me through employmentlawyer.ca. Again, employmentlawyer.ca, address is here. No one should suffer through a toxic work environment. So I'm glad you reached out, Lindsay. You can ask a follow-up question if you want. Otherwise, reach me through employmentlawyer.ca. Guys, you guys are awesome. You guys are asking me lots of questions. Keep them coming. I'm going to answer all of them. I'm going to continue right now. In fact, I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin, LLP. Let's get to some more questions. Nathan has our next question. I was asked to sign a non-compete after already working at the company for 2 years. Is that enforceable? That's not the right question. So here's what I mean. Because it may not be enforceable. There's probably a 99% chance that it's not enforceable. But that's not really the question. The real question is, will the company try to enforce it? If they try to enforce it, they'll take legal action against you if you breach it. It could get messy, expensive, quite ugly. So that's the concern, not whether you're ultimately going to win, because you will, but that could be a 3-year legal battle that's going to cost you a lot of money. So with the non-compete, you're better off not having signed it, okay? On the other hand, if you do sign it, let's figure out a way, if you're going to leave the company, where you can work with them not to breach it, or work with them that you're going to, you protect their secrets. You're not going to go after their customers, but you want to work wherever you want. We need to have that conversation. You cannot sign a non-compete assuming it's okay and then go ahead and breach it. If you do that, that's just an invitation for legal trouble down the road. So you have to take non-competes very seriously, even if it's actually not enforceable. For most people, it's not enforceable, but it doesn't stop a company from trying to enforce it. So please do the smart thing. Be very careful with these non-competes. If you're asked to sign one, let me see it. Let me go over it with you. We can negotiate it out often. And if you did sign one and you're going to leave the company, let's have that conversation before you go ahead and compete so that you can avoid legal action. All right. So thank you for that, Nathan. Very important question. Thank you for asking. You can reach me, of course, through employmentlawyer.ca. And I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, live right here, right now, answering your questions. I'm going to continue answering them. Ask them. You have so much time still. So ask the questions. All right. Let's see. Next question is from Shan. I think it says Shan. I was forced to quit after I told my boss I need to relocate back to the East Coast. I work a remote position and was told that I cannot move and will need to resign. So, yeah, if you're working in a particular province, even if you work remotely, if you're going to relocate to a different province, the company doesn't have to allow that because that different province has different rules, different laws. It may be illegal for them to employ you there. They may not know how to comply with the laws there, so it's a big deal. So if you were hired to work in Ontario, as an example, and you work and live in Ontario, even if it's from home, and now you want to move to or relocate somewhere out east, you're going to go to New Brunswick, the company doesn't have to allow that. And if you move, you've resigned. So unfortunately, that is the case. Now, if you are moving within the same province and you work remotely anyway, no problem. But once it's a different province, it's a different set of rules, and the company does not have to agree to that. So if you move anyway, that is considered a resignation, unfortunately. I know it's not fair. It's not what you wanted to hear, but that's kind of how that would work. And by the way, Shan, if you want to ask a follow-up question, happy to answer. If there's other factors that I didn't know about or some other information, ask it away. I'd be happy to answer. So let's see. Fantastic questions, guys. You guys are awesome. As always, love you guys. Ask questions. Again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. Let's see. Next question. The one and unknown has our next question. I am resigning from my job. My employer is demanding I repay $1,000 for a firm-organized new hire conference I attended last year. Contract has a repay clause, but it is broad. Is it enforceable? Well, I'd have to see the contract. Potentially it is. If you sign something that says, if you're attending this conference, you're agreeing that if you leave, you're going to have to pay us back. Potentially it is enforceable, and you would have to pay it back. Again, I would have to see it. I'm not going to be able to comment on whether something is drafted well enough to be enforceable without actually seeing it. So you can send it to me. I'll take a look, and I'll be able to tell you what it does. Of course, you can reach me and all my contact information just by going through employmentlawyer.ca. Now, the one thing they can't do is they can't deduct it from your pay. So unless you give them written permission, they can't deduct that amount from your pay. So they can't say, hey, your final pay is $1,200, but you owe us $1,000, so we're going to deduct that $1,000. They can't do that. But what they can do is potentially, if you don't repay, they could take legal action against you. Will they take that for $1,000? I don't know them. I can't say. Probably not, but who knows? But you have to consider that. It starts with that employment agreement, very important document. So happy to look at it. And if you have that, you can send that to me again, employmentlawyer.ca. Thank you for that. And we see that, by the way, sometimes where an employer does something for an employee or pays something. Maybe it's some specific training or other entitlement. And there's a clause that says, we'll do this for you, but you agree that if you leave us voluntarily before a certain date, you have to pay back some or all of it. So you have to be mindful of that. All right. You guys are awesome. By the way, you still have questions. If you ask a question right now, I guarantee you an answer on the session before we shut down for the day. So again, I'm Lior Samfiru, the employment lawyer, live here answering your employment law questions. Workplace rights, harassment, accommodation, discrimination, wrongful dismissal, constructive dismissal. You name it, this is the time to ask questions. And our next question is from Mel. Mel says, I've been working for 15 years. I'm 52 years old. My employer eliminated my position, but they offer me severance pay. Right. Well, the question is, of course, Mel, which you didn't tell me anything about it, is how much severance? Because you're owed severance. Now, I don't know anything about the type of job that you have, but after 15 years, at the age of 52, you're at least going to be owed a year's pay, at least 12 months. And it could potentially be much more than that. The more senior a position you have, the more you're going to be owed over and above 12 months. But certainly 12 months. If you're offered less than 12 months, it's a wrongful dismissal. Even at 12 months, it could be potentially inadequate. So you can tell me now how much you received, or even better, just reach me. We can have a private chat, and I can actually help you get the severance that you're owed. So Mel, to connect with me, I've said that before. I'm going to give that to you again right now. Just go to employmentlawyer.ca right here, employmentlawyer.ca. You'll get the phone number there. You get the email addresses there. You can get the fax number is there. So check it out. So it's a question of severance. It's about making sure that you get everything that you're owed. So thanks for that, Mel. All right, you guys are awesome. Lots of questions coming in. More questions is what I want. Next question today is from Wild Out. I'm 35, fairly young, but have been working with the company for 10 years now in a managerial role. Would 6 months of severance be enough? Nope, not even close to being enough. You're probably going to be owed about 10 months. And again, depending on the level of managerial role and how much you're earning, it could be even more than that. It could be even more than 12 months. Certainly not going to be less than 10 for you. So even though you're young, 10 months. Now, that is almost not quite double, but almost double what you've been offered. So if you're offered 6 months, that's probably a wrongful dismissal. You and I need to speak. You and I need to make sure that we go over it and make sure that you get what you're owed. The good news is it's not going to be difficult to get you what you're owed. Once I get involved, I'll ask for 15 months. I'll come back at 8. I'll ask for 12. We'll resolve it at 10. I think you get the idea. So that's what I want you to do. Reach me through employmentlawyer.ca, and I'll make sure you get what you're owed. Okay. You guys are great. Fantastic. Let's see. By the way, if you're just joining us and you're wondering what is going on here, why is this guy talking about stuff? I'm Lior Samfiru, the employment lawyer with the law firm of Samfiru, Tumarkin, LLP, and you've landed on my live stream session where I answer questions about employment law and workplace rights and tell you what you need to know about your rights and make sure you have answers to your questions. So ask your question. You still have time. You guys are great today, asking me lots of questions. I'm going to continue answering them, and I want even more than that. Okay, Secret Baby has our next question. How do I ask my boss or workplace for a family accommodation that has recently come up? Okay, so the best way to do it, in writing. Okay, so you're going to send a note to your boss, whoever the right person is, telling them what's happened. Okay, you have to be detailed. So, for example, if it's a childcare issue, well, I have a child that has to be at daycare at this time. There's no one else that can take them. So I need flexibility to be able to come in late. So give them that information. Tell them why, and tell them why it has to be you as opposed to someone else in writing. The reason you want it in writing, so you don't want them to say later, we didn't know, you didn't really tell us, we didn't understand. In writing, as simple as possible. Now, the duty to accommodate based on what we call family status is very important. If there's a childcare issue or an issue maybe taking care of your parents, and the only way you can meet that obligation is through accommodation by your employer, that employer has to provide the accommodation, okay? So I want it in writing. If they cooperate, fantastic. If they don't cooperate, if they ignore you, if they say no, let me know. I've done this many times. Usually, as soon as they hear from me, all of a sudden the company says, oh, no, of course we're going to accommodate. It was just a big misunderstanding. Yeah, we'll give that accommodation. Hopefully you don't need that. So hopefully you can do that on your own. With an email, works really well. But again, give them the details, explain why, and explain why you need their help. Okay, thank you for that, Secret Baby. Follow-up questions, of course, you can ask right now. I'm still here and you still have time. All right, let's continue answering questions with me, Lior Samfiru, the employment lawyer, live here. Live, which means you still can answer your questions. Oh, no. You can ask your questions. How about that? Make a deal with you. You guys ask, I'll answer. I think that's a fair deal. All right. Alicia has our next question. I'm a salaried worker for a nonprofit organization. They've been talking about replacing a number of roles with volunteers. If I'm replaced, am I owed anything or no because of the industry? Yeah, absolutely. So this is a great question. Some people think if you work for a nonprofit, they don't have to pay severance. Nonsense. Not only do they have to pay severance, they have to pay severance the same way and in the same amount as any other organization would. The law does not distinguish in terms of severance between for-profit or not-for-profit. So if you're let go, you're absolutely going to be owed your full severance. And depending how long you've worked there in your job, that could be as much as 24 months' pay. I mentioned it at the beginning. Let me mention it again right now. We have the severance calculator. You can find out yourself right now how much you're owed. Just go to pocketemploymentlawyer.ca. It's right here, pocketemploymentlawyer.ca. Click on the severance calculator, answer a few questions, and you'll find out how much severance you're owed. Okay? Easy, takes seconds, completely free, completely anonymous. No questions asked of us. You don't have to give your name or the company's name. Just check it out again, pocketemploymentlawyer.ca. Any follow-up questions as well, you can ask them right now. All right, again, I'm Lior Samfiru still, hasn't changed, the employment lawyer, and I'm answering questions about employment law, workplace rights. So let's continue with Gary. I've had to leave my job because of seizures and I can't drive anymore. Can I do anything to get money? Okay, well, first of all, I guess it's a question of, can you do something else? So you may not be able to drive, but is there something else that you can do? Can they give you other work, maybe some work from home? Can they accommodate you in any way, shape, or form? Now, if they can, they have to. So you need to talk to your doctor. Is there, you may not be able to do your old job, but is there another job that you can do? If the doctor says yes and gives you a note explaining what you can do, the company has to accommodate. If you cannot work anymore, you may be owed some severance. If you're in Ontario, and in other provinces, it doesn't work. But if you're in Ontario, you may be owed some severance. It's not going to be a lot. And so it depends on how long you've worked there, and you haven't given me that information. So you can call me and let's have that conversation, Gary. You can call me or reach me through employmentlawyer.ca. All the contact information is there. So, but I would start with, can you be accommodated? If you cannot, and it's clear you're never going to be able to work again, let's talk about severance. Unfortunately, it's not going to be a lot. All right. Great question here from Gary. Thank you for that. You as well, you can still ask questions. Just to like 7 or 8 minutes here on the session. You can ask a question right now. I still guarantee you an answer. All right. Let's continue. And by the way, I have to say this in case you're wondering. I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin. And next question is from Sandra. I was recently on a 3-month sick leave for a back injury. After being cleared to return to work by my doctor, my employer said that my contract was terminated and they will have to renew it. I worked there for 6 years. Can they just start me on a new contract? I don't understand. Well, you haven't given me a lot of information. Were you on a contract, in fact, that expired in the meantime, or are they making it up? So the key is this. The key is, I'm not too concerned about this contract. I'm concerned about you not losing your job. I don't want you to sign anything without me seeing it first, because you may have to sign something that is completely unfair, unreasonable, that takes away your rights. So as long as you don't sign something without me seeing it first, then you're good. They can't let you go in this scenario because you're away. They can only let you go if there's legitimately no more job for you. And that's going to be tough for them to do after only 3 months. So key is, don't sign anything without me seeing it. As long as you do that, nothing bad will happen. All right. So Sandra, you can reach me and send me the agreement through employmentlawyer.ca. Okay, let's continue. Next question is from Amanda. I love this question. Is a 3-month probation mandatory in Alberta, or is that something you have to agree upon and sign? It's not mandatory and it's not automatic. Just because you started a job does not mean you are on probation. Probation doesn't exist automatically. It only has to be created in an employment agreement. So the only time you're on probation is if you sign an employment agreement before you start working that says, in the first 3 months, you're on probation. If you sign something that says that, then you are on probation for 3 months. If there's no agreement, or if your agreement does not say that, you are not considered on probation at all. Okay, great question. I have talked about this often. There's a lot of people that are confused by that. So now you know, probation is not automatic, only if you sign an employment agreement. Great question. Thank you for that, Amanda. All right. By the way, last few minutes here, I'm going to answer some more questions. I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. All right. Anne has our next question. Do I have to use my personal time off for a protected medical leave? It's up to your employer. Completely up to your employer. It's based on their policy. They can force you to use your vacation even. Not fair, but they could. Okay, so that's completely up to your employer. Wild Out has a follow-up question. Is it better to do an individual case or a group case if multiple of us are being let go at once? Definitely individual case, not a group case, because you all have different entitlements. Your rights are not going to be the same as your colleagues. You may be owed 12 months. They may be owed 3 months. They may be owed 24 months. You may be owed 7. I think you get the idea. So no, individual cases have nothing to, is the way to go, not a group case. One case has nothing to do with the other. Okay. It just delays things, complicates things, and it's not even proper. So if you lost your job, let's deal with it. If your colleagues have lost a job, let me talk to them. Let me make sure that their rights are protected as well. And we treat every case individually and give it the attention that it deserves. So thank you for that. So Alicia said that, yes, you're a 7-year employee. Yes, of course. They probably owe you anywhere from 6 to 9 months of severance. So if you lost your job, you got to call me. Okay, Alicia, employmentlawyer.ca, the way to get a hold of me and to have all that contact information. So please do that. Again, non-for-profit, for-profit, big company, small company, doesn't matter. Severance has to be paid. A lot of people believe that a small employer, maybe a company that just has a couple of employees, they don't have to pay severance. Nonsense. Of course they have to pay severance. In fact, severance has to be paid and calculated in the same way as everyone else. The factors that go into calculating your severance are your age, your position, and the length of your employment. The longer you work, the older you are, and the more senior a position you have, the more severance is owed. It has nothing to do with how big a company you work for. So yes, even if you're the only employee and you lose your job, of course you're owed severance as much as 24 months pay. All right, let's see if we can get some more questions. I'm Lior Samfiru, the employment lawyer. Derek, I need help with the WSIB appeal for lost hours and not getting my regular hours on modified duties. Well, we actually don't handle WSIB matters, but we have a great referral for that. Reach me by email, and I'll send you the referral to handle your WSIB matter and to help you with the appeal. Great guy. So again, you can reach me through employmentlawyer.ca. So let's see. Let's take one last question here today, and this one is from Zoe. My employer changed my position without asking me about it, and I don't want to change this. What should I do? So it depends on what changes they've made. Like some changes they're allowed to do. For example, if you're operating machine A, now they want you to operate machine B, that's probably something they can get away with. On the other hand, if you're a manager, now they're making you the janitor, I think you get the idea. Of course they can't do that. So it comes down to what type of change they're making. They're not allowed to make a significant change. So if it's a significant change, you may be able to consider this a constructive dismissal and leave with your full severance, okay? So that's what you want to keep in mind. If it's a minor change, yeah, they could probably get away. Major change, they can't. If you want to talk about what the change it is that they've implemented, is it a major change? Is it not? Is it a constructive dismissal? Let's connect. The devil's in the details, and you can reach me through employmentlawyer.ca. All right, fantastic. This 30 minutes just flew by. Why? Because you guys kept me busy. You asked me lots of questions. I love it. That's why I'm here for. So thank you for that. Always a pleasure to join you guys here. But now that we're done, not going anywhere. My team's not going anywhere. We can continue the conversation. You can still get help. You just have to go to employmentlawyer.ca, and phone numbers there, email addresses there, all the contact information so that we can continue this. I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. It was great to be here with you guys. Looking forward to doing this again and connecting with you through employmentlawyer.ca. Have yourself a good day and a great weekend. Thanks, guys.